afternoon, everybody. This is John Giardinelli, and I am the association's attorney. This rant's going to be a little bit different than what we've done in the past because of what's going on in the world. So first of all, let me tell you when I'm recording this because that's critically important. I'm recording this at about 11:15 a.m. on November the 8th. It's important to know that because everything I tell you may not be relevant on November the 9th. So here's what's going on. As many of you have heard, there was a trial that was recently conducted in Kansas City, Missouri. NAR, among other defendants, was sued for antitrust violations, and it was claimed that because NAR requires in its MLS rules that an offer of compensation be made, which is typical of most statutes, including California's, that was an antitrust violation. They're claiming essentially that by requiring a seller to make an offer of compensation in the MLS, combined with the fact that statistically the overwhelming number of closings showed that the commission to the buyer was roughly half of 4 to 5%. And they also introduced at trial training materials from the brokerage defendant showing how an agent could maximize compensation by only showing properties allegedly that were offering a certain amount of money. Well, the jury came back with a $1.78 billion verdict against NAR and the broker defendants. Several other defendants had settled beforehand for about $155 million. So where are we today on November the 8th, 2023? Well, we know that there was a judgment that was entered for not a judgment, but a verdict that was entered for $1.78 billion. The judge said, y'all been here for 2 weeks, sent everybody home, said we're going to schedule sometime in November, December, the hearings on everything else that needs to be done. So what needs to be done? Well, number one, the judge has to decide that under antitrust law, if he should treble the amount of the verdict, which would mean that the verdict would end up being about $5.4 billion. He also, and this is the most important, he also needs to decide if he's going to issue an injunction, and I suspect he most assuredly will, against NAR from continuing to enforce clear cooperation, from continuing to enforce the rules regarding mandatory offers of compensation, and what, if anything, is he going to replace it with? That combined with the fact that it was announced yesterday, November the 7th, that the attorney for the plaintiffs, a guy named Ketchmark, has been working with the Department of Justice, and it's been now claimed that the Department of Justice is actually assisting in drafting the injunction. So that probably will give rise to certain changes in the way you conduct business, which I'll talk about in a second. There's a whole bunch of other procedural issues that have to take place, and until they do, I'm reluctant to talk about them. For example, the NAR has indicated that it's going to appeal. If it does, it's going to probably have to post a bond in order to prevent the plaintiff from being able to collect on the judgment. They're going to have to finalize the injunction after hearings. They're going to have to approve the settlement with Remax and Anywhere. Things of that nature will need to take place. Then there'll be the appeal. The appeal is probably going to take a couple of years to resolve. Maybe not that long, but certainly 18 months is not unreasonable. So again, there's a lot still to be resolved, but there are a couple of things that I think are going to be pretty clear. Number one is that mandatory offers of compensation commencing pretty soon, quote unquote, is going to be the case. You will no longer be allowed to be, or will no longer be required to offer compensation to buyer's agents in the multiple listing service. How that's going to look is open to speculation, but it's pretty clear that listing agents will no longer be required to say, if you find me a buyer, I will offer you X% of my commission on the listing side, which of course means listing commissions may go down, probably will, but only to the extent that that you will no longer have to offer part of that to the buyer side. That could be positive in some ways because that may prevent agents that list property from trying to double end because of potential for liability. So that probably is going to happen. More than likely, within the next 6 months or year, it's going to be mandatory that a buyer's broker have a written representation agreement similar to what's being offered today, which is the buyer representation broker compensation form, commonly referred to as the BRBC. And then thirdly, you're probably going to have to do a better job, some of you, in explaining, what do you bring to the table? You bring a lot to the table. There's no doubt about that. And we're writing some stuff to help you out in presenting that to your buyers. But you're going to have a conversation early in the process, perhaps even before you start showing property, saying, look, I have to have you sign this agreement, but here's what I'm going to do in exchange for that. And you're going to explain the value proposition. And then fourthly, you're probably going to have some type of a buyer presentation format so that you can lay out the process if you're going to represent the buyer. So that's probably coming sooner than later. So it's going to be important that you understand that you're going to need to have a written buyer representation agreement. And if I were you, I would be looking for classes, if you're not already one of the rock stars that are using the buyer representation form. CAR has announced that it will be offering their program for free. We may be offering some programs here at the association coming up soon, including perhaps even a live presentation. There's going to be a lot of opportunity for you to be trained by some very competent people on how to use a buyer representation agreement and how to talk to your clients about why it's best for everyone if you do. Once it becomes mandatory, if it does, and I believe it will, then the argument by the buyer that, well, I'm not going to sign it because I don't want to be bound to you, probably will go away. I was talking to a broker recently, and she indicated to me that all of her top producers require an exclusive buyer representation agreement with compensation, and then they know they're going to get paid because they don't have to worry about the buyer slipping out the back door at the last minute. So that's probably going to happen sooner than later, even with an appeal, because the injunction doesn't necessarily stay those parts of the rules. I've been asked a lot, is the verdict that took place in Missouri going to be enforceable in California? The answer is no. However, because it's not a California case, it's a Missouri case. So the holding is limited to that jurisdiction that the federal court covers in Missouri, which does not include California. However, NAR is a national organization, and if they are ordered to take certain steps, then those steps will be taken on a national level, and everyone will be bound by whatever is decided. So that is taking place. Today, another lawsuit was filed, and this one was filed by buyers, claiming that the buyers are forced to pay more for a house because they're forced to pay for the listing agent's commission. A similar case was dismissed not too long ago in Illinois, so we'll see how that flies presently. Filed in a different court. So that's taking place. In addition, of course, the Department of Justice continues to press NAR for removal of all vestiges of mandatory offers of compensation, and they may get their way through the Burnett Sitzer case in Missouri if they're allowed to have a substantial input into how the injunctions are handled. So what does all this mean in terms of how you handle your side of the deal if you are a buyer's agent? Well, first of all, the listing agent isn't off the hook completely because they're going to need to be very careful about what they say in light of what was decided in Missouri. For example, you're probably going to be in a bit of trouble if you say something to the seller about, if you don't offer a certain amount of compensation, nobody's going to show your house. That probably is not going to be something we're going to recommend you do down the road. More than likely, there'll be much more transparency in terms of commissions and what's wrong with that, right? If you go to an automobile mechanic, they give you an estimate of charges. If you go to any other retail, you're going to know what you're going to be paying for a product or a service. If you go to your CPA, you're going to want to know what they're going to charge you. Go to the doctor, you're going to want to know what the copays are, right? So what's wrong with knowing what it's going to cost me for professional advice? There's probably going to be some negative fall off in terms of buyers who are not able to independently hire their own agents. They may be forced into dual agency, which may or may not be a good thing for them. If they don't have the money, they're not going to have the ability to hire their own agent, and might get stuck with either a less experienced agent or maybe no agent at all. And so and of course, you've got FHA and VA buyers and the limitations imposed on them by virtue of the regulations. What are lenders going to do? We don't know. Right now, frankly, it's a fiction, but lenders really do pay the commissions because if the property appraises, they'll make a loan and the loan will cover the purchase price, and the purchase price has buried in it the commissions paid to both the listing agent and the buyer. So we're going to probably see some issues there. We'll probably see down the road some changes relative to more experienced agents versus new agents. It's always been a question, and it was raised at the trial. Why does an agent with virtually no experience get to charge the same amount of money as an agent who has substantial experience and substantial success? You're probably going to see a lot more direct negotiation between the buyer and the seller regarding the payment of the buyer's commission. Right now, the purchase agreement allows you to do that if you have a signed BRBC, and we'll probably see that practice expanded. So there's going to be more than likely a lot of changes. Now, I'm doing another rant in a couple of weeks, and by then perhaps we'll have some information on what the judge is actually going to do with the injunction, with the bond for the appeal, with the trebling of damages, with the approval of the settlement and the anywhere remax portion of the case, and we'll have a lot more to give you. Right now, I'm reluctant to say more than what I've already said because I'd be speculating, and that doesn't do you any good, but we will keep you posted. It is critically important that you keep up with the association's announcements. The government affairs directors, myself, my law firm, everyone is working very, very hard. Staff at CAR, staff at the association, everyone is working very hard to push out accurate, relevant information so that you can make good decisions. Strong suggestions, start thinking about taking a buyer representation class somewhere soon, because you're sooner than later, you're going to need to know what's going on. Well, that's about it for today. So with that, this is John Giardinelli signing off, and we'll see you in a couple of weeks. Thank you very much.